Hello and welcome back to this channel. Happy Hump Day! December 3rd. There is a lot going on. My name is Mandy Magnan. I'm an actress, writer, producer, and director in Toronto, a movie reviewer, pop culture, and your YouTube commentator for everything. It ends with never. As we all anxiously await the filings coming in from Jones versus Abel, and Blake Lively has a whole bunch, and then the Wayfarer response. There's a lot still coming out. Nothing has been filed yet as I make this video, but we're waiting for it. But there are still some other things to go over. So today we're going to go over in this video Wayfarer's response to the New York Times, a couple of filings, one from Jed Wallace, one from Stephanie motherfucking Jones, and then I just want to show you something that's happened in the court listener from Blake Lively. We'll get into it, okay? So grab your emotional support lip gloss. You are in frame with Mandy Magnan. In the last video I just did, we talked about Popcorn Planet's motion to quash being denied yesterday. It does show in the ruling from the judge that there are pages, like 42 pages of text messages between him and a defendant, a Wayfarer defendant, as well as some other messages. And I don't know what they're going to have to do. They're going to have to try to appeal and or go to Judge Lyman or something, because really they should have to only hand over anything that has to do with the Wayfarer defendants, any communications on social media, as well as only up until February 18th. That's the cutoff. Also, I feel like her subpoena was served late per Judge Lyman's rules. So there's a lot there that they can kind of work with. And I hope that they definitely fight it, because they shouldn't have to give up all of their sources and everyone that they talk to for the documentary. The documentary has nothing to do with the claims that Blake Lively is claiming. So we're going to see there. I think it's just a really bummer of a situation. And in my opinion, it seemed very biased, and the ruling was a little bit old school when it comes to journalism. However, it is what it is for now. We'll see how Andy Signor and Popcorn Planet replies. But definitely I'm sending them a lot of love, and I want them to know that we are all with them and we're standing behind them, and the fight continues. On the screen, what you're looking at is the only thing filed from Blake Lively thus far, and it's her redactions. Remember, Judge Lyman put in that 12-page order that from now on for sealing and redacted stuff, you have to follow a pretty tight criteria. You can't just seal everything because you feel like sealing it. I mean, I'm paraphrasing, but that's kind of like the point. But any personal information, medical information, emails, phone numbers, client information, that stuff obviously can get redacted, but everything else needs to come unsealed. So he had ordered Stephanie motherfucking Jones, Blake Lively, and Wayfarer defendants all to refile with redactions. So this is what Blake Lively filed, but as you can see, you can't get to it. You have to buy everything on Pacer. It's currently not available to even view. And what I think is funny is this is the letter from Blake Lively, and it just says, plain and simple, "Dear Judge Lyman, in accordance with your Honor's order dated November 26th, Plaintiff Blake Lively hereby refiles publicly redacted versions of Exhibit 10, 12, 14, 15, 18, 20, 21, 22, 32, 33, 30, blah, 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 blah." All of these, right? But you can't get to them. Like, you have to buy them for now. So I don't know if they're going to fix that or if they're going to change it, but right now you have to buy all of them, which I will do if I have to. But there's nothing here from anyone else except Street Relations, Skyline, and again, the depositions redacted this time from Jed Wallace, as well as I believe there was some from Wayfarer and Melissa Nathan and Jones Works. So still no communications, no nothing from Lively's team or anything from Blake Lively to prove any of her claims. This is all coming from the Wayfarer defendants and now non-party Jed Wallace. I'll be real honest with you. I'm not sure if there's like a setting when you give things to the court, whether you have to purchase them or not purchase them. I've never had to buy anything from Court Listener. Usually the attachments, like I'll show you again, but usually the attachments just come as is if they're not sealed. So I'll just show you kind of like if we go to more at the top what that looks like. Like, it's not like I don't want to get you the information like this time. It's just it wasn't filed where I can, even though their letter says that they publicly filed it. But usually when everything's filed, you see how it's in blue. You can just click on it and get the stuff unless it's under seal, like these ones are under seal. But most of the stuff, when it's under blue, you can get to it. So like this one would on 1017, if you see it, it's like main document and then the attachment, and like these ones. So all of these attachments, for example, you could actually click on and get to it. But for some reason, the one that Blake Lively just filed is, no, you can't get it. Judd Wallace has filed a very interesting letter, I suppose, to Judge Lyman about the redactions and unsealing of documents, and it reads a little something like this. We write on behalf of non-parties Judd Wallace and Street Relations, collectively the Wallace non-parties, pursuant to the court's November 26, 2025 order docket 1027. They love using the non-parties, and I love it too because it is bitter and petty, and I am here for it, okay? The court ordered parties and non-parties to publicly file certain exhibits to which those parties or non-parties proposed redactions. With respect to the Wallace non-parties, the court adopted their proposed redactions to Exhibit 27, 28, and 36 to Lively's motion for spoliation sanctions, and ordered those exhibits be filed publicly with the adopted redactions by December 3rd. Exhibits 27, 28, and 36 with the Wallace non-parties proposed and adopted redactions have been publicly filed on the docket and are accessible to the public. Dockets 914.2 and 914.3 and 914.7. The court further ordered the Wallace non-parties to submit proposed redactions of Exhibit 55 to Lively's motion for spoliation sanctions and Exhibits 35, 39, 40, and 41 to Jones Works' motion for spoliation sanctions. Consistent with the court's order, the Wallace non-parties provide under seal with this letter proposed redactions to the identified exhibits to protect the identity of clients or prospective clients, including information that might lead to the identification of those clients or prospective clients. The Wallace non-parties respectfully request the court adopt the proposed redactions submitted herewith and order the continued sealing and redactions of the identified information. So we'll see what's in those information if the court is going to file his redactions or not. And in the Jones versus Abel case, there was a case management and scheduling order letter dropped today as well. So this is for Judge Lyman. It's pursuant to this court's February 3rd order. Plaintiff Stephanie motherfucking Jones and Jones Works LLC, together the Jones parties, and defendant Jennifer Abel, Melissa Nathan, Justin Baldoni, and Wayfarer Studios LLC, the Wayfarer parties, respectfully submit this joint status update in advance of the scheduling conference on December 9th. Existing deadlines. The current deadlines are as follows. December 22nd, deadline to exchange expert rebuttal reports. January 16th, deadline to complete depositions of experts. Outstanding motions. The Jones party's motion to dismiss Wayfarer's amended counterclaims remains outstanding. The Jones parties anticipate filing an amended complaint to conform to recently discovered evidence. Okay. She is going to file an amended complaint this far in the game? Okay, Stephanie motherfucking Jones, you do whatever you got to do, girl, like whatever. Jones parties. The Jones parties have requested that the Wayfarer parties advise whether they intend to stipulate to the amendment or oppose it. In the event of Wayfarer parties do not consent to amendment, the Jones parties intend to move to amend for good cause shown as required by Rules 15 and 16. Heck yeah, they're going to oppose it, girl. What do you mean? Are you going to oppose it or not? Damn Skippy. Wayfarer parties. The request is premature as the Jones parties only advised the Wayfarer parties of their intent to amend on December 2nd. Although the Wayfarer parties requested a copy of the proposed amended complaint with a red-lined copy, the Jones parties declined to provide either. Further, the court's scheduling order required all amendments to be filed by April 18th, 2025. The Jones parties have not offered any facts demonstrating good cause for amending the complaint as required by Rule 16b. So that's what the Wayfarers are saying, like, girl, April was way back. April was when the amendments needed to happen. I don't know what's going on here. This is sounding kind of nuts. What do you mean she's going to try to amend with new evidence? What new... we continue. Okay, discovery. The parties completed fact depositions on October 10th. Expert discovery is ongoing and rebuttal expert reports due December 22nd and expert depositions to be completed by January 16th. Settlement. The parties will be prepared to discuss the status of settlement discussions with the court on December 9th. Remember the one that was in the Lively case? Under settlement, they said, we're not talking settlement. Here, they're like, hey, we're actually prepared to talk settlement. Very interesting. Anticipated length of trial and jury trial. This case will be tried by a jury. The Jones parties anticipate needing 2 weeks of trial time. The Wayfarer parties estimate that trial will take 3 weeks. Summary judgment. The Jones parties anticipate filing motions for summary judgment. So on top of an amendment, also summary judgment. Okay. The Wayfarer parties anticipating filing motions for summary judgment. Yeah, I would think so. The parties are prepared to schedule summary judgment, the proposed joint pretrial order, and trial during the conference on December 9th. The parties thank the court for its attention to this matter. Okay. We were also that was not English. We were also supposed to get responses back from the Wayfarer as well, but they have filed a letter for a continuance. And this is what that letter says from Wayfarer, which was filed today. Defendants, Wayfarer Studios, It Ends With Us, Justin Baldoni, Jamie Heath, Steve Soritz, Melissa Nathan, the agency group, and Jennifer Abel. Collectively, the Wayfarer parties respectfully move the court on an expedient basis for an order modifying the court's individual practices in civil cases. Specifically, the Wayfarer parties seek an extension of the deadline to file their opposition to Blake Lively's motion to compel regarding the Wayfarer parties' signal privilege log. There is good cause for this request. The motion includes new arguments. Oh my gosh. Every time she's filed now a motion for these signal messages, there's always new arguments. Like she's really trying to do more fact discovery versus motion to compel. The motion includes new arguments that were not raised previously by Lively and thus could not have been anticipated by the Wayfarer parties. Specifically, Lively argues that the Wayfarer parties have waived privilege as to certain documents listed on their privilege log, a serious contention that requires care and attention in briefing to assist the court in its ruling and to defend the Wayfarer parties' assertion of the attorney-client privilege and other privileges and protections. For good cause shown and for the reasons set forth above, the Wayfarer parties respectfully request an extension of the deadline to file their response to December 5th, 4 days after service of the moving papers, which is 2 days longer than the ordinary deadline applicable to discovery letter motions and 3 days shorter than the deadline applicable to noticed motions. No previous extension of this deadline has been sought. We thank the court for its prompt attention to this matter. But that was filed earlier today and still nothing from the judge. Now tonight we are still waiting Lively's opposition to the Wayfarer's motion for judgment on the pleading. We're waiting for JonesWorks' opposition to Abel's motion for summary judgment. We're waiting for Lively's opposition to the Wayfarer party's motion for summary judgment. And we're also waiting for the Wayfarer party's opposition to Lively's motion to compel. I guess now we're probably not going to get the opposition to Lively's motion to compel because they asked for an extension. Don't come at me, but I don't think the judge is going to like that very much because it was due today and they filed a letter today for an extension. However, he's been giving Blake Lively extension after extension after extension after extension, so he might be fly with it. I don't know. We're going to have to see. You never know. You never know with Judge Lemon. The Wayfarer parties have replied to the New York Times and they filed just with answers only, kind of what Stephanie motherfucking Jones did with Jennifer Abel. Remember, it's just like answer, 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 answer. So what we're going to do is just go through line by line and see exactly what they're answering. The complaint from New York Times was only 11 pages and the answers from the Wayfarer is only 6, so it shouldn't take that long to go through it. And then maybe we'll get some stuff from Lively tonight before midnight. I don't know. But what we do have now is Jed Wallace's, some of his depositions unsealed. So I'll have to go through those as well. But let's just do one by one. And right now we're doing the New York Times, okay? Okay, I tried to do something a little fancy-dancy. No, it's not. Anyway, here we are. So on the left-hand side of the screen, you have the New York Times complaint. And on the other side of the screen over here, you have the Wayfarer answers. The New York complaint, the Wayfarer answers. Okay, this is what we're going to do. We're just going to read the New York Times, and then I'm going to compare the answers that were given by Wayfarer. Nature of action. This is an action brought pursuant to New York Civil Rights Law 70A and 76A to recover costs, fees, and expenses incurred by the Times in the defense of a defamation action brought by Wayfarer and parties associated with Wayfarer. See Lively versus Wayfarer Studios. Wayfarer, paragraph 1 consists of legal conclusions that require no response. To the extent a response is required, Wayfarer denies the allegations in paragraph 1 and respectfully refers to the court to the complaint, which speaks for itself. New York Times, cause of action 2. Strategic lawsuit against public participants. SLAPP suits are lawsuits used to inhibit the exercise of free speech and harass publishers by forcing them to expend time and resources on baseless litigation. Wayfarer says paragraph 2 consists of legal conclusions that require no response. To the extent a response is required, Wayfarer denies the allegations in paragraph 2 and respectfully refers the court to the applicable statute, which speaks for itself. New York Times. New York's anti-SLAPP law offers redress to targets of SLAPP suits. On November 10th, 2020, New York's governor signed Assembly Bill 5991A into law, substantially expanding New York's existing anti-SLAPP law to provide greater protection to publishers against frivolous litigation intended to silence their exercise of the rights of free speech and petition about matters of public interest. Wayfarer answers in the exact same way that consists of legal conclusions that requires no response. New York Times. Under New York's anti-SLAPP law, defendants in lawsuits involving public petition and participation may now file an action to recover damages, including costs and attorney fees, from any person who commenced or continued such an action without a substantial basis in fact and law. The anti-SLAPP law also provides for compensatory and punitive damages against plaintiffs who, like Wayfarer, commence or continue meritless legal claims for the purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting the free exercise of speech. Wayfarer says that those are legal conclusions that require no response and, to once again refer to the court for the applicable statute, which speaks for itself. The anti-SLAPP law applies to lawsuits targeting any communication in a place open to the public or a public forum in connection with an issue of public interest or any other lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with an issue of public interest, with the term public interest defined broadly to mean any subject other than a purely private matter. I think this is also good as well for Popcorn Planet, if I'm being honest, because why do they get away with it and they can talk about the case, but he can't? It's okay, that's I digress. Wayfarer answers in the same manner, just saying that those are legal conclusions that require no response. 6. It is now well established that news coverage of matters of public interest fall within the scope of the law. Wayfarer says that consists of legal conclusions that require no response, but if a response is required, Wayfarer denies the allegations. 7. The New York Times is a corporation with its principal place of business at 620 8th Avenue, New York. The Times is the publisher of the New York Times. Wayfarer says Wayfarer denies knowledge and information sufficient to form a belief as to the truth of the allegations in paragraph 7. Upon information and belief, Wayfarer is organized as a limited liability corporation under the laws of the state of Delaware with its principal place of business in Los Angeles, California. Wayfarer answers that it admits the allegations in paragraph 8. Jurisdiction and venue. This court has jurisdiction pursuant to New York Civil Practice Law and Rules 301 and 302. The basis of this claim is that Wayfarer tortiously commenced and continued a SLAPP suit against the New York Times. Wayfarer answers that paragraph 9 consists of legal conclusions that require no response. But if they need to respond, yet again, they deny it, okay? Venue is proper pursuant to CPLR 503A and C because the Times' principal place of business is in New York County. Venue is also proper because Wayfarer tortiously commenced and continued the SLAPP suit that is the basis of this claim in New York County. Wayfarer answers with that consists of legal conclusions that require no response. But Wayfarer does deny the allegations in paragraph 10, except admits that the consolidated action was filed in the United States District Court for the Southern District of New York. On December 21st, 2024, The Times published a news article authored by Megan Twohey, Mike McIntyre, and Julie Tate titled "We Can Bury Anyone Inside a Hollywood Smear Machine," and an accompanying video. The article and video reported on a sexual harassment and workplace retaliation complaint filed by actor Blake Lively and the California Civil Rights Department in connection with her work on the film It Ends With Us, which was produced by Wayfarer. Ms. Lively filed the CRD complaint against Justin Baldoni, who directed and starred in the film, and co-founder of Wayfarer, and Jamie Heath, Wayfarer CEO and the film's lead producer. Interesting that it's not It Ends With Us LLC, huh, babes? The CRD complaint incorporated documents including text messages and email communications between Mr. Baldoni, his publicist Jennifer Abel, and a crisis PR specialist, Melissa Nathan. The article and video explicitly relied on and cited to the CRD complaint and the documents referenced therein to report on Ms. Lively's allegations that Mr. Baldoni and Mr. Heath engaged on misconduct on the set of the film, and Mr. Baldoni subsequently engaged Ms. Nathan to tarnish Ms. Lively's reputation. Funny how she's saying that she only relied on the CRD complaint to write the article in her complaint, but in the video that she made, which metadata shows that it was way before even receiving the CRD complaint, she said that she herself personally went through thousands of pages of text messages and had phone calls with Blake Lively where Blake Lively said, "Meh, it wasn't that bad. I've been through worse, but it is what it is. I wasn't going to say anything, but now that they've smeared me, so which is it? Here you're saying that it was filed off the CRD, but in your video response, you said that you yourself went through thousands of pages of text messages. Wayfarer's answer is that they deny the allegations in paragraph 11, except admits that the Times published the article and the video on December 21st, and that Blake Lively filed a complaint with the California Civil Rights Department. On December 31st, 2024, Wayfarer and its affiliates filed suit against the Times in California State Court for defamation and false light arising out of the publications of the article. Wayfarer says they admit the allegations in paragraph 12. On December 31st, Ms. Lively filed suit against Wayfarer as well as Mr. Baldoni, Mr. Heath, Steve Saretz, It Ends With Us Movie LLC, Miss Nathan, the Agency Group PR LLC, and Miss Abel in the United States District Court for their Southern District of New York. Wayfarer admits the allegations in paragraph 13. On January 16th, 2025, Wayfarer, along with Mr. Baldoni, Mr. Heath, Mr. Saretz, It Ends With Us Movie LLC, Miss Nathan, the Agency Group, and Miss Abel filed a lawsuit against Miss Lively, Ryan Reynolds, Leslie Sloan, and Vision PR in the United States for the Southern District of New York. On January 30th, 2025, the action was consolidated with Miss Lively's lawsuit. Wayfarer and its affiliates did not originally name the Times as a party in this case. Wayfarer denies the allegations in paragraph 14, except admits that the actions was filed on January 16th and the action was consolidated with the Lively's lawsuit, and that the Times was not originally named as a party to the action. On January 31st, 2025, Wayfarer and its affiliates filed an amended complaint naming the Times as the defendant in the consolidated action. Wayfarer denies the allegations in paragraph 15, except admits that the amended complaint was filed on January 31st. In the amended complaint, Wayfarer and its affiliates asserted 4 causes of action against the Times. Wayfarer denies the allegations in paragraph 16 and respectfully refers the court to the amended complaint, which speaks for itself. Dang, okay. They're playing a little hard here, and I like it. First, Wayfarer and its affiliates asserted a claim for defamation against the Times for reporting that it had engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively, and retaliated against Lively for reporting this harassment by propagating false and misleading narratives about her for the purpose of damaging her image and reputation. The amended complaint specifically challenged a single concrete statement from the Times video, which stated that Baldoni and Heath hired a crisis PR manager who orchestrated a smear campaign against Lively. Wayfarer denies the allegations in paragraph 17 and respectfully refers the court to the amended complaint, which speaks for itself. Next, Wayfarer and its affiliates asserted a claim for false light against the Times. The false light claim was based on the same statements as the defamation claim. Wayfarer denies that allegation as well and respectfully once again refers the court to the amended complaint, which speaks for itself. Finally, the amended complaint asserted claims for promissory fraud and breach of implied contract against the Times. Those claims were based on a December 20th, 2024 email from the Times seeking comment from Wayfarer and its affiliates before publication of the article. The email requested that they provide the Times with a response by noon on December 21st. The Times published the article at 10:11 a.m. on December 21st. Only after receiving comment from the attorney for Wayfarer and its affiliates. The amended complaint tried to construe the email as promising that the article would not publish before noon on December 21st. Yeah, that's usually what happens. You say, hey, I'm not going to publish this until you give me an answer, but if I don't get an answer from you, I'm publishing at this time. And then y'all just went ahead and published anyway after even saying that. So why even say that? Ugh. However, Wayfarer denies the allegation and respectfully again refers the court to the amended complaint. On February 28, 2025, the Times filed a motion to dismiss the amended complaint with prejudice pursuant to Federal Rule Civil Procedure 12B. Wayfarer admits the allegations in that paragraph. Following briefing on June 9th, the district court granted the Times motion and dismissed all claims against it with prejudice. Wayfarer admits that is true. It is unclear from the district court's opinion that the claims against the Times lacked any base in fact or law. Wayfarer denies that allegation and refers the court to the opinion of the judge, which speaks for itself. Preliminarily, the district court held that New York law applied to the defamation and false light claims against the Times. The district court noted that the statements emanated from New York, where the Times is located, and that decisively, New York has strong policy interests in regulating the conduct of its citizens and its media. Wayfarer denies that paragraph. First, the district court dismissed the defamation claims against the Times. As an initial matter, it held any statements in the article and video reporting on the alleged sexual misconduct experienced by Lively were not actionable because they were based on the CRD complaint and therefore were subject to New York Fair Report privilege, and separately were not plausibly made with actual malice. Unbelievable. I'm still so mad over this ruling. As for Times statements about the smear campaign, to the district court found, to the extent they fall outside the privilege because they relied upon communications not included in the CRD complaint, they were not plausibly made with any actual malice. The district court specifically noted that the CRD complaint and article contained numerous messages and documents strongly suggesting the Wayfarer parties did spread negative stories about Lively, and that a reader of those messages would have little doubt that the Wayfarer parties engaged in a smear campaign. The district court rejected the idea that actual malice was established by certain text messages that the Times allegedly saw and suggested that the negative publicity about Lively was coming from sources other than Baldoni and his associates. Those texts did not overcome the reasonable inferences to be drawn from the text indicating there was a smear campaign, even if others on their own attacked Lively online. The district court also noted that the article's inclusion of additional context favoring Baldoni and the prominent incorporation of the plaintiff's denials cut against an inference of actual malice. In sum, the amended complaint failed to adequately plead multiple necessary elements of a defamation claim. Wayfarer parties deny that and again refer to the order from the judge. Second, applying the New York law, the district court dismissed the false light claim because the state does not recognize this cause of action. Wayfarer denies. Finally, the district court dismissed the promissory fraud and breach of implied contract claims, holding that they were meritless. The district court found that no contract existed, and an email at most was a promise that Wayfarer and its affiliates had until noon to provide comment on the reporting. As the district court noted, their lawyer did just that, and his statements were included in the article. Wayfarer denies that, and again, go and read it yourself, right? Like, get out of here. The Times incurred not less than $150,000 in legal fees and costs for defending against the lawsuit, which had no basis in law and fact. Wayfarer denies knowledge and information sufficient to form a belief as to the truth of the allegation in paragraph 27, except denies that the amended complaint lacked a basis in fact and law. It's $150,000 in New York Times. You fighting this now is probably going to cost you more than what it did then. Like, you're just doubling up at this point. Causes of action. The Times repeats, realleges, and reincorporates the allegation in the foregoing paragraphs as though fully set forth therein. Wayfarer repeats and realleges the preceding paragraphs as if it is fully said herein. They just repeated the exact same thing that they said. New York's anti-SLAPP law provides that in an action involving public petition and participation, a prevailing defendant shall recover damages, including cost and attorney fees, from any person who commenced or continued such action. Paragraph 29 consists of legal conclusions that require no response. The lawsuit against the New York Times was an action involving public petition and participation under New York Civil Rights Law 76A. It was based on a news article published by the Times, communications in a public forum in connection with an issue of public interest, and lawful conduct in furtherance of the exercise of the constitutional right of free speech in connection with the issue of public interest. Well, Wayfarer says that paragraph consists of legal conclusions that require no response, but if they do, guess what? We deny it. And check the statute to the law because it speaks for itself. The district court's opinion makes clear that the Wayfarer and its affiliates both commenced and continued the lawsuit against the New York Times without a substantial basis in fact and law. Well, they're gonna deny that allegation. Thank you so much. Under such circumstances, New York's anti-SLAPP law requires that the Times be awarded its cost and attorney fees and such other compensatory damages as the court deems just and proper. Wayfarer denies the allegations in paragraph 32. Further, Wayfarer denies that compensatory damages are recoverable because the action was not commenced or continued for the sole purpose of harassing, intimidating, punishing, or otherwise maliciously inhibiting the free exercise of speech, petition, or associated rights. By operation of law, Wayfarer is jointly and severely liable for the damages resulting from the baseless claims brought by the New York Times. Wayfarer denies those allegations. And then we get into the affirmative defenses by Wayfarer. The first affirmative defense by Wayfarer is plaintiff's cause of action is barred in whole or in part because Wayfarer's amended complaint was not a SLAPP. Second defense is the complaint fails to state a cause of action. Third, plaintiff's cause of action is barred in whole or in part by the doctrine of waiver. Fourth, plaintiff's cause of action is barred in whole or in part by the doctrine of estoppel. Fifth, plaintiff's cause of action is barred in whole or in part by the doctrine of unjust enrichment. Sixth, the plaintiff's cause of action is barred in whole or in part by the doctrine of unclean hands. That's right. That's right, Van Zandt. That's right, fake lawsuit. That's right, sham subpoena. New York Times, you should be ashamed of yourself. You and Blake Lively and Stephanie motherfucking Jones and everyone else that was involved. Whew, okay. Seventh, plaintiff's cause of action is barred in whole or in part for failure to satisfy a condition precedent to commencement of this action. Eighth, plaintiff's cause of action is barred in whole or in part by its failure to mitigate its damages. Ninth, plaintiff's cause of action is barred in whole or in part by the First Amendment in the United States Constitution. 10th defense, if plaintiff sustained any damages as alleged in the complaint, such damages are attributable in whole or in part to conduct on the part of plaintiff, its agents, or its employees. Do you hear that, Megan Toohey? 11th, plaintiff has not incurred damages as a result of any actions, inactions, or conduct by Wayfarer. Request for relief. 1. Dismissing the complaint with prejudice. 2. Awarding Wayfarer its costs and expenses incurred in this action. And 3. Granting Wayfarer such other and further relief as the court deems just and proper. Okay, party people. Well, everything I showed you before that was like still sealed and you had to pay for just came unsealed. Oh my gosh, I'm going to go over everything tonight and then I will be back tomorrow to give you all of that information plus the replies. Where are the replies? You know, it is getting late. What's going on? But those are going to be coming out too, so there's a lot. Okay, so bear with me. I'm going to get everything to you tomorrow, the next day, every day until we get all the information. That's it. I don't think Wayfarer is too concerned right now with the New York Times because they're only asking, like, no offense, but for $150,000. Blake Lively's over here asking for over $500 million. You feel me? You feel me? So we'll see what happens there. But as everything starts rolling out, I will be with you. Okay. I hope you're having the best hump day. And yeah, I will talk to you very, very soon. I love you so much. I'll talk to you soon. Bye.